Good morning, Mr. Shaskalson. Good morning, Mr. Premhead.
Morning, Chair.
Morning, Chair. Morning, Commissioners. Chair and Commissioners, you'll recall that 3 weeks ago, Mr. Karim was postponed to today's date. He's not here today, and we received a doctor's note yesterday that refers to his admission to hospital on the 17th of June, which is more than a month ago. When we received that doctor's note yesterday, it seemed to explain Mr. Karim's apparent inability to appear today, but it didn't explain his inability to answer, at least in part, the Regulation 10.6 notices that had been served on him and that I addressed in the Commission 3 weeks ago. You'll recall, Commissioners, that we're still waiting for Mr. Karim to tell us, for example, who the auditors of his companies are. There's nothing in his doctor's note that suggests that his health conditions are of such an order that he's been unable to do that for 2 months. Similarly, we're still waiting for Mr. Karim to furnish audited or even unaudited financial statements for 3 of his companies, Ziggy, Tasmika, and Tamiz. There's nothing in the doctor's note that suggests he'd have been unable to issue a simple instruction to the officers of his companies to do this. And I want to emphasize here, we're talking about a group of companies, including Ziggy, Tasmika, and Tamiz, that have been paid hundreds of millions of rands from the Northwest Provincial Government and Northwest municipalities in the region of which he's the ANC Treasurer. Companies in this group continue to perform services for those organs of state and continue to be paid millions of rands by those organs of state. We're talking about multi-million rand businesses, not, family-run sort of small businesses that have to shut down if their owner is unwell. So if Mr. Karim took the trouble to ask someone, he ought to have been able to arrange that we receive the financials we've been asking for months now. That's where things stood yesterday. Mr. Karim seemed to have an excuse for not appearing, but he did not seem to have any excuse for failing to answer any of the questions in the Regulation 10.6 notice we sent him 2 months ago, and for not providing any of the documents we sought in that notice, almost all of which he had undertaken to provide when he testified when he was healthy back in, I think it was April. That was yesterday. And then after we received the doctor's note under cover of a letter from his attorneys yesterday, late in the afternoon yesterday, we received 2 different whistleblower reports, both confirming that Mr. Karim and an entourage had been seen yesterday going out for lunch at a shopping centre in the Western Cape. The 2 reports corroborated the same details. They seem to be independent of one another, and they've now been confirmed by eyewitnesses at that shopping centre, who we have independently contacted. So we now have it from multiple different sources that someone who seemed very much to be Mr. Karim arrived at the shopping centre with an entourage, went into Woolworths before going off to have a late lunch at a restaurant in the shopping centre. We've subpoenaed CCTV footage from the shopping centre, and we expect to have it received, and we expect to have it thoroughly analysed by midday tomorrow. For now, we have a concern that Mr. Karim may be taking liberties with this commission. And that concern is amplified by other whistleblower reports that we've received indicating that Mr. Karim has been seen at social gatherings in the Northwest over his period of ostensible incapacity. So we are going to issue a subpoena later today to the hospitals at which he's been receiving treatment to establish when he was admitted and when he was discharged, since he testified at the Commission. We're also going to be issuing a subpoena to his doctor, who's based in Cape Town, to establish the dates on which he has seen Mr. Karim. And we don't expect that it will take us more than a day to obtain this information. And what we would like is for the matter of Mr. Karim's appearance, or non-appearance, to be stood down until Friday morning, or maybe Friday lunchtime, when it can be considered on the basis of a formal postponement application, which we would ask this commission to order him to bring by 10 o'clock tomorrow. The evidence leaders will reply to that postponement application by 6 p.m. tomorrow, and it could be heard by Friday morning at 9:30. If Mr. Karim's legal team needs more time, if we can have that postponement application by 5 p.m. tomorrow, we would undertake to respond to it by 10 on Friday, and it could be heard on Friday afternoon, not Friday morning. But what we do expect the postponement application to address is at least the following issues. The dates on which Mr. Karim has been admitted to hospital over the last 4 months, the dates on which he's attended medical consultations over the last 4 months, his travel movements over that period, whether he's attended social engagements over that period, and whether he's played any role in the management of his businesses over that period, and if not, who's been responsible for these businesses which continue to turn over in his absence.
Ms. Jaskarson, can you please add one more thing? I'm interested to know how he traveled from the Northwest to the Western Cape. Did he book flights? Did he fly there? Because if he can give instructions to people to book flights to him, surely he can give instructions to people to give you the names of accountants. Thank you.
So that is our request, Commissioners, that the matter stand down to be decided on the basis of a formal postponement application on Friday.
Thank you, Mr. Jaskarson. Yes, Mr. Premier.
Good afternoon, Chair. Good afternoon, Commissioners. 5 brief points in reply, if I may. Firstly, do you have the Commission's correspondence bundle? I was handed one about 10 minutes ago by a Commission representative, but it's called Karim Suleiman Correspondence and Sundry Documents Witness Bundle. I'm going to refer you to the confidential medical report in that. I'm not going to discuss the contents, but if you can turn up page 128 of that medical report, when you read paragraph 1 of that report, that will deal with my learned friend's contention that there's an inability to explain attendance. And when you read paragraph 2 of that same report, particularly lines 2, 3, and 4 of the second unnumbered paragraph, that is a direct response by a medical practitioner as to why, potentially, there's an inability to give answers. So insofar as my learned friend says there's just no explanation at all, that's contradicted by the medical evidence of an expert in a particular field of medicine, which my learned friend is not. That's point number 1. Point number 2, my learned friend must choose his words very carefully with all due respect, because my learned friend talks about hundreds of millions of rands, companies that are continuing to service the state, multi-million rand businesses and so on, and he uses the quantum of my client's otherwise legal business to evidence some or other gratuitous behavior in front of the Commission. Until such time that a court orders otherwise, that there was unlawful business dealings with the state to the tune of those hundreds of millions of rands, the fact that there's business that may or may not be done to the tune of hundreds of millions of rands is neither here nor there. So my learned friend must choose very carefully his words in elevating otherwise perfectly legal facts to be weaponized into some sort of smear, potentially, against my client and otherwise lawful activity. The third point that I would say, in respect of Mr. Karim's undertakings to give the evidence, is you'll know that Mr. Karim, if you'll give me 1 second. I'm indebted to Ms. Matlangwane. On the 13th of April, suffered the medical incident, and at least on our version, he has been in medical treatment since then. And so his ability, notwithstanding undertakings whilst given in the box, must be construed having regard in particular to that second paragraph that I referred you to on page 128 of the bundle. Can I say, in number 4, in respect of these whistleblower reports and the alleged corroboration or not corroboration, corroboration, that has occurred or not occurred, 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 that has and this is a two-part point, so you'll forgive me. The first part of which is we only learnt about these facts today. I know my learned friend says he also only learnt about these facts today, but apparently these social gatherings were known about before. And it's the first time we're learning about these things today. And I must place this on record, in as much as I don't for 1 minute question my learned friend's ability to rely on those allegations to raise a question about Mr. Karim's position in front of you. We would respectfully submit, and I know earlier there was an exchange about whether respectfully is respectfully or not respectfully, but I'm respectfully submitting.
I'm happy you were listening.
Yes, no, the commission is warmed up by the time I come here, so I know what I'm walking into. The point that I would make is that it's unfortunate we're learning about these in an open proceeding of this kind, and that these demands about what this formal postponement application needs to entail in an open session of this, rather than to have had an opportunity, even after either a stand down or a postponement was asked for today, given that the client is not here because he's presently in the hospital. So it's unfortunate we've learnt about it in this way, but my learned friend and I throughout the morning have been talking intensely about what he can give me and what he can't give me, and whether he's going to give me the CCTV footage he's already got in his possession or he doesn't. Well, I don't think we're in agreement on that, but my learned friend very kindly my learned friend has very kindly given me the license vehicle registration of the vehicles that were apparently transporting my client or not transporting my client yesterday, and we'll deal with that in due course. All I'm saying is that the manner in which we've learnt about this is regrettable, and the reason it's regrettable, and this is the second point of my fourth point overall.
How do you suggest you should have learnt about it?
That is a segue, thank you, Chair, to the second point I want to make under this, is that with all due respect, I'm now concerned that we are inadvertently using the postponement application and the allegations regarding the movements of my client or otherwise as a mechanism through the back door to undermine the otherwise unimpugned medical evidence in front of you. And Chair, you asked me how should we have learnt about it. With all due respect, I don't think it's for my client necessarily, unless you order otherwise. If you order it, well, then we have to do it. But if you don't order it, it's not for my client, with all due respect, to answer these accusations in the ether in the way that they are, where the overall purpose or effect is to create doubt about the medical excuse.
That's a different issue. You raised an issue, or rather, you complained about having lent of the information in the manner in which that happened. So I'm asking you the question, how do you suggest you ought to have gotten to know about the information? That's different to what you are saying.
Yes, Chair, thank you. The way in which we should learn about it, and I know Chair says to me it's a different issue, I will respectfully say it's not a different issue, is because if the purpose or effect of that accusation is to raise doubt about my client's medical condition and whether there's a legitimate excuse for his attendance or non-attendance at the commission, because that's what the sting of that accusation actually is, then actually the shoe should be on the other foot, in the sense that it should be the commission, the evidence leaders, bringing an application where they raise this evidence in the round of questioning the medical advice or otherwise, or the medical reports or otherwise that have been tabled in front of you that otherwise serve as the excuse. It's not the hill I'm going to die on. All I'm simply saying is that I'm concerned that the way in which these accusations now have to be dealt with is almost reversing the onus that otherwise falls on my client.
That still doesn't answer my question.
I apologize, Chair.
Yes. The question of how Mr. Karim must respond is something other than your suggestion about, maybe the word I'm going to use will be strong or too strong, the impropriety that you suggest with regard to how you came to know is what I am addressing. That has nothing to do with how Mr. Karim then deals with the information. So my question is, how do you suggest this information ought to have landed on your or Mr. Karim's lap?
In writing and particularized, so that it's formally placed in front of us, rather than as what happened between my learned friend and I, which was a conversation between colleagues regarding these issues that are now being raised. So that's when I talk, and Chair, with all due respect, impropriety is a far higher word.
That's exactly
Yes.
why I
Yes.
said maybe it's too strong a word.
Yes,
Yeah.
because I'm not accusing my learned friend or anybody of impropriety. I'm just raising my concern about the manner, and then that's the direct answer.
Maybe instead of impropriety, I should have said concern,
Yes.
which is the word you've just used now.
Yes. So, Chair, I think we're ad idem then that it's concern, not impropriety, and formally in writing, because these are very serious accusations, and I understand that my learned friend is under his collegial obligation to give me notice that he was going to raise it today at the hearing, but he could have we could have reached some or other arrangement about being informed about this formally and then given an opportunity to respond. But we are where we are now, so that's water under the bridge, I suppose.
Yeah, I was going to say, why is it that the informal advice cannot serve the same purpose as written advice?
Well, I suppose because my learned friend is not the witness. So when my learned friend, and neither am I. So when my learned friend says to me, these are the core of the allegations, it might turn out that some or other detail about that is going to change or not change, and there should never be a dispute between my learned friend and I as to what he said to me or what he didn't say to me. I mean, if my complaint is at this point only boiling down to housekeeping about the form of communicating the information, I accept that might not be an issue which needs to detain the Commission.
The issue, as I understand it, is not so much about the interaction between the two of you. It's about Mr. Karim addressing what we are told has since been discovered.
Yes.
So the focus is less about the interaction between the two of you.
Exactly.
And the point being, if indeed it is true that Mr. Karim was at some food outlet out of town, I think reference was made to his vehicle or vehicles, I'm not sure now whether one or two or more. So point is, when you apply for the postponement, why is it, or rather when he, Mr. Karim, applies for the postponement, why is it that he should not, in the application for a postponement, deal with those? If he says, I was never out of town, I was never at this alleged food outlet, and therefore, my medical certificate stands, and it is to this effect. Nothing has changed. I do not see what the hurdle is, Mr. Karim, dealing with the new information on that basis.
Agreed, but I think that's also I'm sorry, Chair.
Yes.
May I respond?
Yes, please.
Thank you, Chair. But that's the point, with all due respect, is that, remember, when we arrived here in front of you today, it was on the basis of what was known before my learned friend disclosed the new information.
Yes.
But now what's happening is new information is being introduced, which may need to be dealt with to justify future postponement, but the basis upon which we're here in front of you today is the different historical facts, not the new facts introduced now.
But that's exactly why Mr. Karim is being afforded an opportunity. And it's not as if Mr. Shaskalsin is saying, and we want Mr. Karim to deal with this now.
No.
And that's it. Mr. Shaskalsin is suggesting to the Commission that Mr. Karim must be afforded an opportunity to file an application / affidavit dealing with these developments. So, in the light of that, I would suggest to you, subject to what you say, in the light of that, it should not matter much what you originally came here for today. Things have changed, and because things have changed, Mr. Karim is being afforded an opportunity. So unless other submissions are made, I do not see what the unfairness to him would be. Mr. Karim, because of these developments, bring an application which will be heard on Friday at whatever time. It could even be in the afternoon. And deal with these developments. Tell us why you are not able, for example, to provide the Commission with the information it required, or to give the necessary instructions to whoever may do so, to give the Commission that information. So in that application, he must deal with all of that.
That's why.
And issue, as I understood Mr. Shaskalsin being, this information was requested a long time ago, and Mr. Karim has not provided it on the basis that he is not well. Now, these developments referred to by Mr. Shaskalsin, at face value, suggest that Mr. Karim is going on about his life. That raises the question, if that be so, and underline if that be so, how can it be that he is not able, either himself to furnish that information or to do so through others? And he's afforded an opportunity to respond and say, I simply cannot. And to do that, and to move the application on Friday. I'm not saying that's what we are going to rule, but that is what Mr. Shaskalsin is submitting should happen.
Yes, Chair, and I accept that. That's why
Yes.
that's why I placed manner and form no higher than a concern, rather than using that favorite A word of ambush, and also claiming trial prejudice and fair trial rights. I was, with all due respect, simply placing on the record a more subtle concern from my client. That's all, and that's why I've resisted putting it higher than that. May I just say that in respect of the face value concern and the timing of the evidence and the way Chair posits to me what Mr. Chaskalson put to you, Chair, you've already heard me on that page 128 paragraph of the bundle as the explanation. But insofar as and this is now...
Please take me to the relevant lines of the first paragraph, the first substantive paragraph, not the intro.
Yes, the first substantive paragraph is about whereabouts. So that's inability to attend, to use my learned friend's phrase.
In respect of the second paragraph,
yes,
you referred us to specific
the explanation,
lines.
yes.
Specific lines.
If you look at the second sentence beginning on line 2...
Starting after. We're not going to read it.
No, we're not going to read it, indeed not.
Is that the one starting after?
No, given.
Oh, given.
On my side, I have given.
Oh, okay. All right.
I'm indebted to Commissioners Baloy and Kumalo.
I thought you referred to the first paragraph as well.
Yes, I.
So I had no problem at all with the second or the last paragraph.
Yes.
So what I was raising with you was, please direct me to something on the first paragraph. So are you saying you said nothing about the first paragraph?
The Chair, just to be clear.
The first paragraph starting Mr. Karim.
Well, the problem is they both start Mr. Karim.
Oh, let me look. Has been the big paragraph.
Yes, okay. So
Mr. Karim
the
has
bean paragraph,
yes,
if we can call it that.
Yeah, do you have lines you want to refer to?
No. In the bean paragraph is the whereabouts explanation.
Okay,
And if I have to point you to particular lines, I would say from the date mentioned in
Okay.
3, running on to 4, as it continues. And then there's an explanation there which I don't need to go into.
Okay.
And then in the second paragraph,
Yes.
the remains paragraph, not the been paragraph. In that paragraph, I would ask you to look at the second line, the second sentence starting given. And I would say that that second sentence, which runs on to line 4, ending before the word his, is the critical one regarding inability to explain. The third sentence, which starts his present, that also adds color, but the critical one is the sentence I've highlighted. So that's the face value explanation. That's the response to Chair's point about face value and explanation. But Chair, can I, on my fifth point, I said to you 5 points briefly. It's not that brief, but fifth point briefly, is the timetable. I've heard my learned friend where he's given 2 options for the timetable. He says 10 o'clock tomorrow, reply by 6 o'clock, Friday 9:30 for argument. Alternatively, if I'm not mistaken, he said 1700 hours tomorrow, 1000 hours, they'll respond the next day on the Friday, I think, and then we'll argue on the Friday afternoon. Can I just make 2 points about that? Obviously, the first one is obviously we're in your hands regarding your directive and the timetable for the hearing of that application. Before we entered the room, I did specifically ask my learned friend if he would consider our ability to have that argument next Friday, because you will know that in the correspondence there's consistently been the issue raised about our ability to take instructions directly from Mr. Karim and having to rely on the medical practitioner and the family. And so there might be practically some delays in obtaining the level of specific instructions that we have to now obtain. But as I say, I'm in your hands on that. You will direct as you need to direct. The second point, and I think my learned friend and I have reached an in-principle agreement on this, but if I'm wrong, no doubt he'll correct me in reply, is that Friday, insofar as, I'm just using Friday as the placeholder date, Friday, insofar as we end up needing to discuss medical conditions, hospitalization dates, even identity of the medical practitioner and the speciality that they may or may not specialize in, obviously impinges potentially on my client's medical privacy rights, and also around causing unnecessary public, in an open sense, public speculation about his state of being or not being. And I've already flagged with my learned friend that we might need to be because for the exact reason that I can't read to you what the contents of the medical report actually says. I have to use all these sideways descriptions of directing your attention to content. It might be appropriate for us to have that debate at least in camera without the journalists and the outside world reading in, to the extent that we need to go into that medical history and the details. So never mind the timetable issue, Chair. I think in addition to, if you direct that we have to bring the formal postponement application in the way that it's posited, I'm giving advance notice to you as the Chair and the Commissioners, and I've flagged it and I've discussed it with my learned friend, and he was very understanding, I'm grateful, that we might need to then have that as an in-camera session so that my client's medical privacy rights are protected and his dignity is not unduly impaired as a result of what information we, as the Commissioners, the evidence leaders and his legal representatives, need to have a frank debate about in a way that still manages to protect him. So, Chair, those are, may I just check with Ms. Matlala, who usually holds the purse strings?
Yes.
Ms. Matlala says I've done my job, so it's fine. Thank you, Chair.
Thank you. Mr. Shaskalsin, any reply?
A brief reply, Chair. First, in relation to the businesses, why I mention the businesses is not to say that these are unlawful earnings or that these earnings are, proceeds of crime or anything like that. It's to say there is a very substantial business group that is carrying on in the apparent absence of Mr. Karim. And if the group can carry on in the apparent absence of Mr. Karim, then it's not clear to us why we can't get, through a simple request from Mr. Karim, details like financial statements of 3 of those companies in the group, the identity of the auditor of 3 of those companies who we still haven't been able to ascertain from repeated requests to Mr. Karim. So if he can keep his businesses ticking over remotely from his sickbed, he can also issue an instruction that the information that exists external to him can be made available to us. And he hasn't done that for months now. The second issue in relation to the medical report is it's curious to hear my learned friends saying we haven't impugned the validity of the medical report, because last time we were here, you'll recall that there was a suggestion on the table that Mr. Karim should make himself available for independent medical examination, and we were told, oh no, you don't have the powers to do that. You're not a high court with powers under the rules. You can't do that. He won't make himself available without you, and you don't have the power to do that. So now we're told you can't examine him, you can't get an independent medical report, but when you have extrinsic facts which give reason to doubt that he is unable either to appear or to furnish information that you've asked, you cannot raise them because you're not impugning the medical report. Well, they can't have it both ways. If Mr. Karim wants to make himself available for our own independent psychiatric or other medical examination, we will do that. And we will arrange that an appropriate specialist dealing with whatever medical conditions he has raised, which range across a very wide spectrum, are investigated and a report is furnished. Finally, I want to emphasize one particular misconception, and it is this. Mr. Karim comes here asking for a postponement without making a postponement application. We have information that makes us concerned about the bona fides of his claim to a postponement application. We are giving him advance notice so that his postponement application can address those issues on which he will have to satisfy the Commission. He seems to proceed from an assumption that he can have a postponement if he wants one, and it's for the Commission to show that he shouldn't have a postponement. It works the other way round. He needs to satisfy the Commission. And in order to satisfy the Commission, he's going to have to address these concerns that we've raised. That's why we've raised it. And that's why we've raised them informally, and that's why we've raised them in advance of a postponement application. In relation to the timetable, we have suggested Friday because we have had a succession of witnesses this week who were scheduled who have not appeared and who are not appearing. So scheduling this postponement application on Friday will no longer interfere with evidence time that we have scheduled. We've had, in fact, all 5 days of scheduled evidence, originally scheduled evidence, or 4 of the 5 days of originally scheduled evidence this week fall away because of postponement applications. So this Friday is not going to interfere with scheduled evidence time. If we get to next Friday, we will interfere with scheduled evidence time. And the debates in relation to Mr. Karim's evidence and appearance and non-appearance have thus far taken up days of Commission hearing time, and we don't have days to waste. So we want it done this Friday because this Friday currently is a day which is sitting fallow. As far as the in-camera concerns raised by my learned friend go, if there are legitimate concerns in relation to privacy, we are happy to accommodate them, but whatever happens in that regard needs to be tailored very tightly so that any in-camera process is confined to that which is necessary to address the privacy concern. Those are our submissions, and we would ask that this postponement application be brought on a timetable where we can give the extra time to our learned friends. They can file their papers by close of business tomorrow. We will respond by 11 o'clock on Friday morning, and the postponement can be heard on Friday afternoon.
Chair, excuse me, Chair, may I seek, firstly, as a matter of protocol, may I seek an indulgence to address you on one point that I must respond to that was raised by my learned friend. It's this point about my client can't have it both ways, about the independent examination on one hand and then subpoena the doctor. You will remember in that general discussion we had the last time, it's not one or the other. My client placed on record that the power of independent examination is open to serious doubt. And you'll remember I explicitly said, I used the phrase, there are less intrusive means that are available to the Commission if there's a doubt about the medical evidence, and the subpoenaing of the doctor is one such option. So there is no inconsistency between what I have said to you today and what I have said to you previously, and that's as far as I'll take it. Thank you, Chair.
Thank you. On this, Mr. Sorry.
Mr. Premier, I understood Mr. Chaskalson to simply be making the point that you are not correct to say this medical certificate has no doubt has been cast on it. And all he was saying was, we have said he should go for an independent examination. That's the only point I thought he was making.
Then please strike what I've just said from the record if I was incorrect in my understanding of what my learned friend said. I just wanted to make sure on the record that there's no ground to suggest an inconsistency. And that's as far as I'll take it. Through you, Chair, obviously. Thank you.
Thank you, Mr. Premier. I guess there's no need to respond, or is there, Mr. Chaskalson?
No, Chair.
Thank you. Just one aspect. I assume that the several issues you itemized are the sort of issues that would have to go to a ruling or the ruling, or not? Remember, you itemized a few.
Yes, I've certainly itemized. I'm not suggesting they should go into an order, but if they aren't responded to if they aren't addressed in the postponement application, we will ask the Commission to draw its own inferences.
We proceed on the basis that Mr. Karim, through his legal representatives, has heard the issues that you itemized.
Just in fairness to Mr. Karim's legal representatives, maybe I should run through them again. And what we were asking for was the dates on which Mr. Karim has been admitted to hospital over the last 4 months.
Just I see the paper is being sorted out, and I think when you started, they were not ready yet. Please, Mr. Chaskalson. Yeah.
The dates on which Mr. Karim has been admitted to hospital over the last 4 months, the dates on which Mr. Karim has attended medical consultations over the last 4 months, his travel movements over that period, how he traveled to Cape Town in the last week, if indeed he or beforehand, if indeed he has traveled to Cape Town. And it seems that he has traveled to Cape Town because one of the medical reports speaks to hospitalization in Cape Town. Whether Mr. Karim has attended social engagements over the last 4 months, whether he has played a role in the management of his business over the last 4 months, and if not, who has been responsible for the management of his businesses.
And Chair, as a clarity, I think Mr. Chaskalson's extension of the travel arrangements covers Commissioner Kumalo's supplementation of the original list, so to speak.
And let me just clarify where it comes from. In his presentation, Mr. Chaskalson said they have information that he has been traveling from the northwest. So I know that there's no airport in the northwest, so unless he drove to Cape Town, I'm assuming he would have flown from either OR Tambo or the other airport. I can't remember what it's called for now. So that is relevant to me, because if you can give instructions to anybody to book flights for you, then you can give instructions to those who are running the business to provide the detail the Commission is looking for.
Yes, thank you. Thank you, Chair and Commissioner Khumalo.
Oh, just, yeah. Perhaps, or before, I'll give you a chance, Mr. President.
I was saying thank you for the clarification and the amplification as to the travel arrangements, because my learned friend said travel arrangements broadly, but Commissioner Khumalo has a specific travel arrangement in mind that needs to then be dealt with. That's what I was saying thank you for. I'm indebted to Commissioner Baloy.
Thank you. And Mr. Chaskalson, perhaps it's best for you to just give a piece of paper to your colleagues.
I'll do that immediately.
Thank you.
Mr. Chaskalson, you have narrowed down his activities, business activities, to management. Can I suggest that it be in the business affairs and not narrow it down to management, because management could easily be interpreted as being purely operational. And what we would like to know is what has been his involvement, if any, in the affairs of his businesses. Thank you, Chair.
I'll do so, Commissioner.
There is the matter of detail around the exact timing about filing, for example. Let's leave you and Mr. Premier to discuss that detail and even the time when the application should be heard. But let me upfront say that the decision I make is for that postponement application to be heard this coming Friday. But the question of when exactly tomorrow the application should be filed, when the answering affidavit should be filed, and the exact time at which the application should be heard on Friday, may I ask Council to please discuss that. And once you have agreed, Mr. Premier is excused, and Mr. Chaskalson can just bring that to our attention, say after lunch, and a ruling then gets made.
Thank you, Chair. We will do that.
Chair, may I please just ask a clarity, and I'm sorry to do this, but you'll remember on the last occasion when I argued for an in-camera application in front of you, part of my submissions was to say, well, the horse has already bolted, because in trying to justify the in-camera, we went to the details. I've already flagged the fact that there's going to be a request for in-camera. Obviously, if the Commission, through the evidence leaders, opposes that request, that's a different story. I'm just flagging now that come Friday, it's not just the postponement that might need to be determined. There would also need to be consideration of the in-camera and how it is going to be argued in front of you in a way that balances.
If in the light of what Mr. Chaskalson said, which I thought was quite accommodative, if that will still be an issue, let's consider that when it arises.
Perfect. I'm indebted.
And Chair, can I suggest something else? That pending Friday, this Commission issues a ruling essentially stopping speculation about Mr. Karim's trying to contain speculation about Mr. Karim's medical condition pending Friday, because the issue is going to be, I don't know how to formulate it, but I do think that there is a risk that coming out of today's hearing, there may be wild speculation in the media. Can I speak to Mr. Premier about that, and when we come back to you with a timetable, we will do that. We will include a proposal in that regard, but it may be I don't know how we take that further.
On the last point you made, Mr. Shaskalsin, may I say, please make it part of the discussion, and let's see what comes out of that. We are subject to what Mr. Law says. We are minded to take an early lunch and come back at 1:45. But of course, we will hear Mr. Shaskalsin first. If Mr. Premier will not be coming back for whatever issue he might still want to address. If there's agreement and there's a draft ruling, then Mr. Shaskalsin will come back and...
I'm indebted. That's very kind. Thank you.
Yes. I've just been overruled, and the suggestion is for us to come back at 2 p.m. We'll adjourn and resume at 2 p.m. Let's adjourn. Mr. Chasselson?
Thank you, Chair. Mr. Premier and I were happily able to reach agreement relatively easily. I have an agreed ruling. Unfortunately, I've had printing difficulties, so if I might read it out to the Commissioners. The first paragraph is that the postponement application is set down for hearing at 1400 hours on Friday, 17 July 2026. The second is that the application will be served and filed on or before 2000 hours on Thursday, 16 July 2026. Third paragraph, the answering affidavit will be served and filed on or before 1100 hours on Friday, 17 July 2026. And fourth paragraph, the replying affidavit will be served on or before 1300 hours on Friday, 17 July 2026.
A ruling is so granted.
Thank you very much, Chair. May
And
I be excused?
you are excused, Mr.
Thank you.
Chasselson.
Thank you, Chair. I have some technical challenges, Chair. There's a document I need to start with. I have it in my electronic version, and we are trying to locate it in your printed version. If it would help in any way, it's
Commissioner,
A32.
let me say this. Commissioner Kumalo has a way of finding documents for us.
That's-
Maybe what you should do is just to describe it sufficiently. He will probably find it for us.
That's exactly where I was going, Chair, to tell that it's A32. It's an affidavit by the witness seeking, I think, an arrest warrant. It's A32 in the docket. I have it, I can project it, but we're trying to find the file number and the page number for your purposes so that we work through it. And I've considered all possible clever means of doing so. And I must say that thus far, it looks very encouraging with Commissioner Kumalo, Chair.
Apologies if I've put you on the spot, my colleague.
But perhaps while we do so, I wanted to. It's midday. I haven't done the preliminaries. My apologies. Good afternoon, Colonel. It's as if we're continuing from morning.
Colonel.
Good afternoon, Chair. Good afternoon, Commissioner. Good afternoon, Council.
Good afternoon, Colonel. Good afternoon. Thank you.
Commissioner Baloyi had some questions for the witness, I think, regarding the Section 27. Yeah, Section 27 affidavit, I think, from yesterday. It wasn't finished. But I wanted to move from that to jump back to Section 27. But perhaps I perhaps should allow Commissioner Baloyi to deal with her issues regarding that affidavit. I'll come back to it. When I come back to it in my plan, that should work.
I appreciate how you're using me to buy time, Mr. It's not lost on me. You can start. I'll catch up. Yeah.
Thank you. If that's the case, then I would invite the witness to CJC 377. We've dealt with this before. It's in file 3 starting at page 681. And that is our A1 statement by Mr. Adams. CJC 377.
Chair, before we continue, may I just come and say, give some input? I think since yesterday, there were three things that I said I will be guided by you, Chair, on aspects, as we discussed, on confidentiality and the docket, which is currently before court. So what I want to bring to Chair's attention, the A1 state...
Sorry, I made a serious mistake. Good afternoon, Mr. Podlani. And apologies for not recognizing you or greeting you.
Good afternoon, Chair. Good afternoon, Commissioners. And apology accepted. It doesn't happen every day that the apology comes from that side of the table. But we take it. Thank you.
Thank you.
Thank you, Chair. Can I proceed?
Yes, please, Colonel.
Thank you, Chair. I think after yesterday's proceeding, Chair, and as the investigating officer in the matter of let us call it the Mukwele docket that is before court, the A1 statement forms part of the docket which is before court. But I tend not to turn on and look at the media and everything that's going in my preparation. But the A1 statement is all over social media and on that aspect. One thing about the affidavit, it contains the name of the complainants, and I have my concerns that that particular A1 statement is an exhibit, and it's a statement that's going to be presented in court. And I'm a bit concerned, and that's why I want to bring it to Chair's attention that I'm not too sure whether there are further documents in this case file that is also going to be flighted out there in the public domain when the case currently is before court. That's just my concern this year. And therefore, yesterday I said I'm here to assist the Commission to seek the truth, but at the same time, I have to be cautious that the matter is before a presiding officer in court, and these witnesses and myself will have to testify. These are my concerns. Thank you, Chair.
Thank you, Colonel.
Thank you, Chair.
Yes,
I hear the witnesses' concerns. My concern is I'm not clarified as to exactly what the witness is raising. Because IDEX counsel is present. And what I think I deduce from what he says is that we should not dig into this particular docket because it's before court. We are back to that sub judice issue. This particular docket is not the one that I indicated we had agreed will be treated with caution, because that particular docket is still under investigation. Which is
docket number 3, as I understood yesterday.
Yes, and
there's 1, 2, no problem, and then number 3.
In fact, it's now number 4.
Oh.
It's number 4. There are 4 of them. 1 and 2 are unrelated dockets. This particular one we are dealing with, and docket 4, concern about the same facts, or arise from the same facts. And I think it's common cause that they concern General Khumalo. So docket 4, the witness touched on it very briefly yesterday, and that is the docket that carries this particular caution that because that one is still under investigation, we should tread carefully. This current docket is the one, the charges for which General Khumalo and other members of the panel were arrested, have appeared in court, are on bail, and we confirmed that there are no further investigations in that matter. The docket in its entirety has been fully disclosed to the accused to prepare for the criminal trial. It was on that basis that it was decided that they will not pursue the confidentiality rights insofar as this particular docket is concerned. So if that is where we landed yesterday, that we will not apply confidentiality to this. How I understand the witness is raising a sub judice point, precisely the point that IDEC yesterday said it was no longer pursuing. That's why I say how to deal with it. Perhaps I would require to get a better understanding, because now I'm in a space where the witness is reviving an application that has been disposed of on the basis, as we mentioned to the chair yesterday, and he placed on record. So is he reasserting the sub judice rule to this docket? If not, is he invoking the right to confidentiality to this particular docket, in which event then we would have to have a full-blown argument as to why confidentiality attaches to this document. But at the same time, it is unfair for me to have that debate with a witness, because it's a legal debate in circumstances where it's represented. So maybe Mr. Botlani would like to come in and explain where we land. Do we reopen that application for argument, or what do we do? Thank you.
Chair.
Thank you, Ms. Zillo. Colonel, I was going to invite Mr. Botlani to be the person who addresses us on this issue. I do not know whether before raising the issue you had alerted him to the fact that you were going to be raising the issue. I do not know. Perhaps let me hear from Mr. Botlani.
Thank you, Chair.
Yes.
I don't understand the concern raised by the witness to be an invitation to the opening of a debate that we've had with our colleague and have closed it in the manner that we have. Indeed, I gave counsel before these proceedings resumed this afternoon. The concern, as I understand it, is the documents being made public. I think it's the flighting of the documents, not that questions on the document cannot be asked. That's not what was referred to me by the witness. So him being asked questions on the documents, it's something that he accepts has got to happen, because otherwise would be hindering this commission from doing the very duties that it has to discharge. But his concern was, as indicated to me, the documents now being available out there in circumstances where some people are still going to deal with them in court. That's what was relayed to me. Not that our colleagues should not ask him questions about the documents.
All right. If some of the questions, because I heard the Colonel even refer to names of people, there is names that may be appearing on the documents. How should the documents be treated? Should there be a need to refer to the names in a context where it's quite clear that that's based on the content of the documents? How are we supposed to deal with it?
It's a difficulty. I've tried to consider it with my colleague, Mr. Ramatsek Sanemi, but we couldn't come up with a mechanism. Because indeed, one cannot say this is a linear process where one can put a blanket statement and say there shall not be reference to names. There are going to be circumstances where the context suggests that reference must be made to a particular name. For instance, if one speaks about the A1 statement, for instance, somebody deposed to it. It's there. And one is not going to be able to speak about the A1 document without speaking about the person who deposed to it.
And sometimes even the point being made may only make sense if specific reference is made to the person.
Indeed.
Yeah.
The A1 statement being, for instance, a case in point. I'm in the hands of the commissioners, really. There is no mechanism that we could come up with as to how do you deal with circumstances such as this, especially, for instance, the docket that we're dealing with. We know that it has been discovered. It is out there. The accused have had access to it.
If I may ask, what is this the same one? Is this the same one we dealt with yesterday?
Confirm, Chair, it is.
Oh. Yeah. What Mr. Law has done is to refer to page 61 thus far. Or 681, I'm sorry.
681, correct.
Yes.
Yes.
And we've been dealing with this document backwards and forwards. So I don't quite understand how the issue arises all of a sudden today. That is the kernel's concern. I know it's not your concern, the kernel's concern. We dealt with this document backwards and forwards yesterday, and we referred to there was it in this one? Yes, there is reference to names here, but of course, in paragraph 3, that's reference to the people that were being investigated. But with regard to just this one document, I do not quite get it what the issue would be or what the concern would be.
I follow you, Chair, because insofar as the document that appears at page 681, to the extent that we went in and out of it yesterday and mentioned names, there's no undoing that.
Yes.
There's no taking back, for instance, reference to a Mr. Adams, because it was done.
Yes.
So I do understand what you're putting to me, that how does it arise, because this is not a new document.
Yes.
I again understood that concern, perhaps, even though I'm not able to proffer to you a solution to the concern, to be referring to not necessarily this document, but further document. But your concern is where context dictates that reference must be made to a particular name, how does the Commission deal with it? I'm not able to proffer assistance, unfortunately, to you. But insofar as the document before you now, if for the lack of a better word, damage has been done, there's no undoing it now.
Thank you, Mr. Boljani. I don't know if you want to respond. But
Yes,
my inclination is to rule that we continue as we did yesterday. We are not talking about any other document. It's a document that we engaged with at length. You, my co-commissioners, and me. We dealt with the document at length. So I just do not follow what the concern should suddenly be.
I would agree, Chair, on the basis that the Chair posits that the horse technically has bolted on this particular document. But I have a bigger concern. There are a lot of documents in that particular docket I want to deal with, and that is the question that I need addressed. Is the sub judice rule going to apply to them? Is confidentiality being asserted over those documents? And if so, I need to know how they are intended to be treated.
Perhaps let me ask this question of Mr. Boljani. Mr. Boljani, it is so, as Ms. Silo says, that this particular docket does not fall, or is not the one about which we were told yesterday there must be caution in dealing with it. This document falls under the first category, which is those dockets will be dealt with as the evidence leader pleases, as it were. I'm putting it very loosely. No issue, no concern about that category of dockets.
And I stand by the representations that were made here on day one as to
so no issue about this specific docket. It falls under the category in respect of which you said no issue there.
Maybe I should start here. The difficulty we have is we represent an institution that has lawyers in it, and there's obviously going to be varying views here and there regardless of the counsel that one gives. But insofar as what we presented here on day one as to the treatment of the documents, we stand by that. The documents, in our view, that are affected by the sub judice rule are as identified by the evidence leader. That remains the position. Right. We stand by that.
But you agree that this one is because there was a separation of the documents. There was one document in respect of which we were told caution must be exercised.
Indeed.
Docket, I think I said documents, docket. And that was just one. And the rest, there was no issue there. I called upon you to confirm, and you did.
Indeed.
So
And I stand by that confirmation.
Yeah, that's how we should deal with it. If this falls under the category in respect of which there is no issue, let's deal with it on that basis. And it should not matter whether IDEC has lawyers, as Mr. Bodlani said. That shouldn't matter. Thing is, when Mr. Bodlani came, we assumed that he had instructions. And based on those instructions, he adopted the position that he did on the first day of the hearing. And we should proceed.
On that basis?
Yes, along those lines.
For avoidance of doubt, Chair, and just to be clear, we are proceeding with the docket on the basis as we concluded yesterday morning.
Yes.
So no confidentiality attaches. There are no restrictions to what I can extract publicly from that docket. That is very key.
Yes.
Because our hearings are public. Anything that is ventilated in this room must be done so publicly. That includes flighting the documents. That's part of the public hearings. Unless confidentiality is asserted in terms of Rule 10.4. So we can't be between seats. And as I understand Mr. Bodlani, I think I agree with him that we had a decision yesterday. There are no restrictions absolutely on this docket, except the usual Poppy Act. Yes. Otherwise, we deal with it as it's necessary. That's how I structured how I'm dealing with the testimony of this witness. The witness seems to want to backpedal that and assert some level of confidentiality without necessarily invoking Rule 10.4 in its entirety. So if that's where we land, and IDEC's counsel and I are clarified as to the position regarding this particular docket, then perhaps I'll call upon the chair to explain to the witness.
I think based on what Mr. Bodlani said, the issue is resolved. I will just say, purely as a matter of courtesy to the kernel, you have legal representation. If you have issues or concerns, you should raise them with your legal representatives before we come in, so that submissions are made by your legal representatives. We cannot have a situation where you address us on legal issues when your legal representatives are here. So from where I'm sitting, the issue is resolved, and this is not anything new. It's on the basis of what was agreed yesterday. And I would assume that you were part of the agreement, or you or IDEC gave instructions in that regard. So from where I'm sitting, the ruling is that we proceed.
Chair, may I respond?
All right, let me...
Thank you, Chair. Let me set the record straight first, Chair.
Yes.
We are here for a purpose, and that is to assist the Commission.
Yes.
And to get down to the truth of what is there.
Yes.
My concerns have been relayed to Council. They are aware. My concerns was also during the consultation process given to the evidence leader. And that was that the matter, the docket, is currently before court. So, but what I want to say, I do not want to come across like we want to hide anything. So when we started the process yesterday, there was no problem. And I said, Chair, if you will remember, I will be guided by you, because as the Chair, you would know where the docket, entry into the docket has been, we will probably have prejudice in it. My concern is that the A1 statement was flagged and it was posted all over social media. So we've dealt with the A1 yesterday and the questions that were asked there, which I responded to uncomfortably. But the main thing is, what other documents are going to be flagged?
How these documents get onto that platform has everything to do with the fact that they are being flighted. And they are being flighted because no confidentiality attaches to them. That was our understanding. That was what was said at the beginning of the proceedings yesterday. And they were dealt with fully in open session yesterday. So I would not understand why there should suddenly be an issue just because they happen to be out there on that platform, that is social media. We have no control over that. Once they are public, they are flighted here, people can grab them and do with them whatever they will.
Yes,
So
Chair.
it's you either claim confidentiality and say the documents should not be flighted, which has not been done here. There's been agreement that they can be, or rather, they can be flighted publicly. They can be dealt with publicly. So, or you could have said, no, they should not be. I'm claiming confidentiality for ABCD reasons, and then the commission would decide whether or not it agrees with what you say. That is not what happened. So I cannot understand why at this late hour you should be raising the issue that you are raising, just because you happen to see the documents on social media. It cannot be.
I understand, Chair.
Yes.
But what I'm saying
Can we please move on? You have your, if you want us to adjourn, and I can give you 5 minutes for you to adjourn, we cannot be addressed by your legal representatives and by you on a legal question. We should have been resolved between you and your legal representatives.
May I request that
You give instructions to your legal representatives. We can't have you, Mr. Bojani has said there's no issue with this. You are suggesting that there is an issue. What do we do? Do we reach a decision between contradictory positions placed before us by you on the one hand and by your legal representatives on the other hand? That's the most awkward situation I've ever seen. If you want us, we can go out for 5 minutes and come back once we've been told to come back.
Could I request that adjournment for 5 minutes, please?
Yes. We'll come back when we are told to. Let's adjourn.
Thank you, Chair.
12. All right, we are ready to resume. Please, you know what to do with your devices. Thank you.
Mr. Bodlani.
Chair, thank you very much for the indulgence. It's much appreciated. And we went beyond the 5 minutes that we had requested. An apology this time has to come from this side of the table. We apologize for that. We have had time with Mr. Pateachi and explained how the process works. In fact, it was not the first time that we did so. He understands why we are currently where we are. There's no dispute about the fact that the docketing issue is with the accused. Nobody knows what he's doing with it. Nobody knows to whom has he revealed whatever content is there. And we've tried to explain those concepts to him and how they impact this process and why it is not available to claim confidentiality, subject to care, and so on. He's ready to testify, and he's going to answer questions that are put to him on the docket. Thank you, Chair.
Thank you, Mr. Bodlani.
And I too must extend my gratitude to my colleague, Mr. Bodlani. I'm happy that we could at least find common ground on this issue. It will facilitate our going forward. It's a pity that we've lost the time we've had, but I believe that going forward it will be a smoother run now that these issues are clarified. Thank you, Chair. Mr. Pateachi, and I must thank you as well for engaging with your legal representatives and for facilitating that we reach the point that we have. Thank you.
Thank you, Council. As I indicated, we want to work together and to cooperate, but I cannot keep something inside when it comes to the witnesses. I had to lay it down, but I understand now, Chair, and we can carry on.
Thank you.
Thank you so much. I had said we will start at CJC 377, which will be in your file 3, starting at page 681. That, as I had indicated, is the A1 statement in this matter that we engaged with yesterday. File 3. You found it. Thank you. And I think it is necessary that perhaps I give you a sense of where our engagement today until it ends, where I'm trying to get to so that the commissioners can have the right understanding and to draw conclusions that they will in time do so on the basis of fact. So I bring us to this document because for purposes of your investigation, this is the start point. Do you confirm that?
Yes, Chair.
Thank you. So we will be looking at where you started up to where you ended with General Khumalo, General Lushaba, and Madondo being criminally charged. So those are the two endpoints. Then we will work through the steps until we get to the end. That is the ultimate purpose of the next exercise. Okay? So then if we, on this document, on CJC 373, if you could turn to page 683, you are now 681, just go to 683. And we looked at this document yesterday, and we agreed that the issues raised in the A1 are in truth at paragraph 2 and paragraph 3. Because paragraph 1 introduces who the deponent is, And paragraph 4 contains the views expressed by the deponent insofar as the contents of 2 and 3 are concerned. And the last one just simply confirms that he does not have an objection to taking the oath. So the meat of this document is 2 and 3. My reading, and I want to test with you, is paragraph 2 as couched, which speaks of involvement of these high-ranking police officials in the manipulation of promotional and security vetting processes to unduly benefit a civilian person. My reading of that is that it speaks to potential criminal activity. Would you agree with me? Or?
That's correct.
Then I go to paragraph 3. Paragraph 3 speaks to highly skilled and qualified senior police officers who applied for the post being overlooked by the CI management who favored Mrs. Mukwele over them.
Correct.
Now, I analyze that to be definitely not criminal based on the facts stated there. It sounds more like a HR complaint. Would you agree with me, or do you consider those allegations to point to criminal conduct?
Yes.
Please.
Oh, I wanted you to please start because you spoke over each other.
Okay, we are now in paragraph 3. So we have agreed as to the allegations in 2, what they potentially point to. Yes. So I say, from what's in 2, that points to potential criminal conduct.
That's correct, Chair.
Okay, then I turn my attention to paragraph 3, and I say, the deponent states that he was informed that there were several highly skilled and qualified senior police officers who applied for the post but were overlooked by the management who favored Mrs. Mukwele over them. Full stop. Now, I say my interpretation of that is this particular paragraph speaks more to HR issues regarding promotions and appointments and does not suggest any criminal conduct as worded. And I'm checking whether that's your understanding, or do you see criminal conduct in paragraph 3?
When you look at paragraph 3 in isolation, it talks about, it's like an HR, somebody that didn't get promoted or was overlooked for promotion. Paragraph 3 only.
Yes.
But when you take paragraph 2 and paragraph 3 and you put it together, it flows from paragraph 2 that something took place, and as a result, people that were more qualified didn't get that particular post. But when you look at paragraph 2 is telling you that there is possible criminality here.
Yes.
Paragraph 3 is just something that flows out. It is not so much of a focus because it's other people that didn't get promoted. This is not about other people that didn't get promoted. This is more about criminal conduct in paragraph 2. Possible criminal conduct.
I see where you're going with this, but I would like to draw your attention to the wording. It's paragraph 3 speaks to people being overlooked.
That's correct.
So you understand paragraph 3 to mean that what's contained in paragraph 3 is a consequence of paragraph 2, and that can be because they were overlooked. It's not like they did not get the position as a result of the manipulation of promotional and security vetting. Is that how you say it's a consequence?
Chair, when I look at it, okay, there's an appointment, and this appointment here stands out that there's possible criminal conduct here on what I'm getting out of here. But with the appointment, all these the appointment, the other people that applied, what the whole thing was about. It's an allegation of a person here being criminality in the appointment of an applicant. So that's why I wouldn't separate the two as 3 from 2. I'll take them all for purposes of the allegation, so that when I look at this and I start to prepare myself, I'm requesting documentation. The documentation that I will request is all the documentation in respect of the post, together with all the applicants who applied for the post. So that's why I take 3 with 2, because when I do my investigation process, I'm going to request documentation for the appointment.
Then, on your understanding, we read 2 with 3 to conclude that there was criminal conduct that resulted in what at first blush might seem to be a purely HR issue. Would
Yes.
that be a fair summary?
Yes.
But the criminal element is there and the sting is in paragraph 2.
Yes.
Okay.
Chair, just to make sure, if you look at paragraph 3 on its own isolated, it's HR. But when you put it together with your paragraph 2, it flows from your paragraph 2, because it's not one person. It's other people that applied for the post too as well, that you are bringing together now when you conduct your investigation. It means that I'm not going to ask for the appointment particulars of the applicant. I'm going to ask for the whole process, if I'm coming across more clear. When you look at paragraph 3, just alone, if there was no paragraph 2, it's HR.
Can we perhaps then land here? It would appear at first reading to be an HR issue with some elements of criminal conduct. Would that be fair? Or is it absolute both together it's criminal? And I have no particular preference. I just want to have your understanding.
It's for me, paragraph 2 is an allegation of criminality.
Yes. Okay. Then we start with this crime that you say is in paragraph 2. We know where we land, because we land in you're submitting an affidavit in support of an application for a warrant of arrest. Now that, Commissioner Baloy, is in file 6. That's the affidavit that I couldn't find in the hard copy files, but only on my electronic version. It's file 6, please. At page 2373. Yes, Commissioner.
I'm going to say, before you start with this document, let me just ask something about
Yes.
that paragraph 2.
Two, 373.
Colonel Padiachi, I'm here.
Sorry, Commissioner.
Yes, before you get to this 2373, let me just clarify something about what you were discussing now with Ms. Sillo.
Sure.
In that paragraph 2 of the A1 statement, what do you say, and I need you to say this and that and that, what do you say is the offense, constitutes a crime in that paragraph 2?
Commissioners, Chair, Commissioners, these unlawful appointments, it's not something uncommon. But what people don't understand, that when you appoint somebody and you give them a gratification, the giving of that appointment or employment and the receiving of that employment amounts to corruption in terms of the Corrupt Activities Act.
Okay, you're moving you're moving too fast. You're wanting to enter a discussion that is still going to happen.
Yes,
We will still get to that topic. I'm looking at paragraph 2, and this is the paragraph in the document that gets you started, right? That's what you've received. So you proceed with your investigation based on what you receive in this paragraph. And I'm asking for you to now engage in an investigation looking at this paragraph 2, and I'm going to point out certain things and see whether is that what you consider to be a crime. So the deponent, Mr. Adams, says that the allegations relate to certain high-ranking police officials being involved in manipulating promotional and security vetting process to unduly benefit a person, a civilian. So I'm trying to find out from you, did you consider the crime to be the undue benefit, 1? 2, it's a crime because they are benefiting a civilian. It's a crime because she had no prior policing experience. Is the crime that she had no management experience? I'm trying to bear it down so that I understand what, in fact, did you consider to be the crime that then results in you applying for the warrant that you're going to be discussing?
Commissioner, when you look at it, you don't just look at it because she's a civilian or anything. I look at it that in the circumstances of what is here, the allegation that a person has been appointed or given an employment with, for a better word, has been appointed irregularly, although the irregularity comes up like HR type of a thing. So you're looking at the appointment for a person from BMW, first of all.
Is that part of the problem? That's hence my question. Is part of the problem that, and you can list the others, I just want to make sure that we're on the same page. Part of the problem that constitutes this offense with other facts is they're appointing someone from an external company.
Yes.
We don't need to mention the name.
Yes.
Mm-hmm.
Yes. I think the first thing is that let's start with the starting point. This is crime intelligence. This is a specialized component. It is a component that I have experience in and where I've worked. And it is crime intelligence, and appointing a civilian or a person from the outside crime intelligence let's leave civilian, pointing a person outside crime intelligence into a highly specialized environment. So these are the small flags that, that comes to my notice. So that's the first one that I can explain to you. And when you look at crime...
But you're not saying that is a crime. Are you saying the fact... Because remember, I'm still trying to understand what is the crime that gets you started, or the allegation of a crime that gets you started to conduct an investigation. Are you, from what you've said now, are you saying it's a crime that it's an indication